I'm LJ Ayala. This is my Death with Dignity project for Professor Colleen Duffy. On November 1st, 2014, Brittany Maynard made the courageous decision at the age of 29 to end her life in Portland, Oregon, 10 months after she learned she had brain cancer. When she made this decision, she posted this message on her Facebook. You can see it here, or you can read along with the slides I have already sent to you. Her death was widely publicized. Her entire journey was widely publicized. She very much became the face of the Right to Die movement in the United States. This is my presentation on the right to die, or death with dignity, or physician-assisted suicide, however you want to call it. So, shortly after Maynard's death, the National Right to Life movement, which is basically an anti-abortion movement, released this statement. Since it looks bad to attack a dying woman, instead they opted to attack the organization that supported her and that she supported in order to give her autonomy in this difficult decision. So let's look at some cases that led up to this. The first case we're going to look at is Elizabeth Bouvier. She was mentally competent and had a college degree. However, she was unable to support herself financially and could not live alone and had to live on public assistance. She had cerebral palsy and was quadriplegic. And so in 1983, she checked herself into a public California hospital and expressed that she wanted to end her life through self-starvation. This did not go well, as the hospital did not allow her to do this, instead force-feeding her through a tube. When she was unable to keep food down, a tube was put into her stomach. Doctors believed she could live 15 to 25 more years as long as she was eating because she did not have a terminal illness. So, Bouvier v. Superior Court, 197 Cal App 3D, I don't know what that means, 1127, went to court. Bouvier argued that the tube should be removed and all medical seizures that she did not consent to should stop. She sued the hospital, insisting that the feeding tube be removed. The hospital argued that the state interests of 1, preserving life, 2, preventing suicide, 3, protecting innocent third parties, and 4, maintaining the ethical standards of the medical profession were more important than Bouvier's rights to refuse treatment. The court decided to side with the hospital because it was determined that Bouvier could live 15 or 20 more years, provided that she had food and was adequately fed. So, there was an appeal immediately. In the appellate court, the trial court's determination was reversed because she had the right to refuse medical treatment. Because she was mentally sound, her decision to refuse treatment was hers and hers alone to make regardless of reason, and her reason for refusing treatment should not have been considered in the trial court. So, because she wanted to die, and that's why she was refusing treatment, that doesn't take away her right to refuse treatment. Her right superseded the state's interests. The state's interest in keeping her alive was not greater than her right to autonomy. Quality of life was to be considered. While she could have lived another 15 to 20 years, her quality of life would have been severely diminished. The court stated that, quote, in Miss Bouvier's view, her quality of life has been diminished to the point of hopelessness, uselessness, unenjoyability, and frustration. She, as the patient lying helplessly in the bed, unable to care for herself, may consider her existence meaningless, end quote. A little harsh, but you get the point. 4, fulfilling the patient's desire to refuse treatment was not equivalent to assisting her suicide. Since Bouvier was exercising her right to forego treatment, and because she was competent for the making of that decision, no criminal or civil liability could be held against the hospital or its workers, which is part of the reason the hospital was worried. The court also said that the hospital could give Bouvier any medical care she consented to, which was pain medication, basically. Bouvier later came out to say that while she still wanted to die, because she was on pain medication, the process of starving herself had become too painful. She considers herself a reluctant survivor, and last anyone checked, she was still alive. Whether or not you agree with the hospital's decision to force treatment on Bouvier, they were not doing anything expressly illegal. In 1977, the Natural Death Act became part of the Health and Safety Code of California. This act was to secure a patient's right to refuse treatment only if death was imminent, with or without treatment. This meant cases where the condition was treatable, or the patient could continue to live with the disease, such as Bouvier's case, where she was living with a condition that would not have killed her, it just would have made her life much less tolerable. The patient could not refuse medical care, and that it may only be exercised when, quote, life-sustaining procedures serve only to postpone the moment of death, end quote. Other than that, the physicians have an obligation to try and keep the patient alive, whether or not they wish to live. Similar laws have been enacted throughout the country in the following year. Next case, Katie Ann Quinlan. At age 21, she entered a vegetative state after consuming a combination of drugs and alcohol on an empty stomach. There was prolonged respiratory failure. They tried to revive her. It didn't work. She was brain dead for a while. She was put on a feeding tube and a ventilator. And on September 12, 1975, 5 months after she entered the vegetative state, her parents filed a suit against the state of New Jersey in family court. So, Anne V. Quinlan. In the original case, the Quinlans, specifically her father Joseph, went against Morris County to claim that as her legal guardian in her current state, he should be allowed to make the decision on whether or not to use extraordinary medical procedures. Basically, they wanted the feeding and breathing tube removed to prolong his daughter's life, and that she should be allowed to pass with, quote, grace and dignity. Morris County found that not only would this be homicide, but Joseph's legal guardianship of his daughter was taken away. Upon the appeal, it was granted back to him, and it was found that he had the right to forego medical treatment on behalf of his comatose daughter. The ventilator was taken off, and Karen Ann lived for 9 more years before succumbing to pneumonia. Something notable about this trial was that the Quinlans used a religious argument in court, citing a priest that they spoke to, who cited Pope Pius XII from 1957, and said that refusing to let her die would be to interfere with the Quinlans' religious belief that, quote, earthly existence is but one phase of a continuity of life which reaches perfection after death, end quote. In the Supreme Court's judgment on this, they expressly said that the right to religious belief is absolute, but conduct in pursuance thereof is not wholly immune from governmental restraint, end quote. This basically means that the argument of whether or not someone is to live or die does not fall under the umbrella of religious freedoms or protection. What that priest was citing, though, from Pope Pius XII, was an address he gave in the 1940s called Address to an International Congress of Anesthesiologists, where he spoke explicitly about the obligation of physicians to provide a ventilator to unconscious patients who have no hope of recovery. He claimed that physicians do not have to provide extraordinary treatment to patients in this position, and that to do so would interfere with a, quote, higher spiritual good. So, as of 1957, the Catholic Church publicly approved of, or at the very least, supported the right to refuse life-prolonging care in non-responsive patients, though they may or may not have approved of euthanasia. The Catholic perspective in the 1980s, however, changed. Pope Pius said his thing in 1957, and then in 1980 there was a declaration on euthanasia that said that with medical advances, the line between ordinary and extraordinary treatment was fuzzy, but that physicians, with patient consent, could choose to discontinue treatment if harm outweighed benefits, and it was not an act of suicide, but an accepting of the human condition. So let's go to Nancy Cruzan. Nancy Cruzan's case was monumental. 25-year-old Cruzan got in a car accident on January 11th, 1983, and flew out of the car, flew into a ditch, and was submerged in water for a few minutes. They revived her, but it was found her brain was not functioning at all. She was declared to be in a persistent vegetative state. After 5 years and no improvement, her parents requested that the feeding tube be taken out, and that the hospital refused to do so without a court order. The Cruzmans got a court order, but the hospital and the Kruzmans got a court order, and the trial court said that she would not wish to continue with nutrition and hydration, and that she had a right to liberty. The case was then pushed to the Missouri Supreme Court, where they reversed the trial court's decision by 4-3, claiming that the feeding tube was, quote, not heroically invasive, end quote, or, quote, oppressively burdensome, end quote. It also claims that the state's interest in preserving life was more valid in a case where the patient was not terminally ill, like this one. She would have been able to live, but she would have no quality of life. This court also questions if a legal guardian's authority extends to the ability to exercise one's constitutional rights on their behalf. So, Kruzan, Redirector, the Missouri Department of Health, 497 U.S. This case was then pushed to the U.S. Supreme Court, where it was asked if the Due Process Clause allowed her parents to decline life-sustaining treatment on behalf of their daughter. The court found by a vote of 5-4 that incompetent persons could not make the decision to decline treatment, and that therefore the state of Missouri's actions to preserve life were constitutional. However, they also stated that this was only absent clear and convincing evidence, the words we know, that Kruzan would have wanted treatment to be stopped. Eventually, some co-workers and some friends and her parents came out and said that she didn't want to, quote, live like a vegetable. There's testimony from Kruzan's doctor that said she was in a living hell, and this was the clear and convincing evidence they needed. The feeding tube was taken out. She passed away December 5th, 1990. Judge Scalia's opinion was concurring with the Supreme Court's decision and claimed that Kruzan's case was equivalent to suicide, and that the right for one to commit suicide would only be protected under the constitutional right to liberty, but that it was still in the state's best interest to prevent suicide. Referencing an earlier case of John F. Kennedy v. Heston, he said that the distinction between passively submitting to death and actively seeking may be merely verbal, as it may be if one adult sought death by starvation instead of by a drug, like Elizabeth Bouvier. If the state may interrupt one mode of self-destruction, it may have equal authority to interfere with another. So, now we get to Oregon's Death with Dignity Act. Senator Frank Roberts, husband of Governor Barbara Roberts, introduced 3 physician-assisted dying bills in 1989, 1991, and 1993. On November 8, 1994, Oregon voters approved Measure 16, which allows physician-assisted suicide in the state of Oregon, a year and 8 days after Frank Roberts unfortunately passed from prostate cancer. For 3 years after that, the law was repeatedly contested by the National Right to Life movement, as you heard in the beginning of the PowerPoint, and on December 7th of that same year, a month after voters approved it, a temporary restraining order was placed on Measure 16. 3 years later, Measure 51 is voted on by Oregon voters to repeal the Death with Dignity Act. 59.91% of voters voted to protect the Death with Dignity Act. This dwarfed the slim margin originally passed by Measure 16. Roughly 1.1 million people voted, and 666,000 voted against the repeal of the act. So who supported it? Though it was not a party issue, 72% of Democrats, 51% of Republicans, and 83% of unaffiliated voters voted to protect the Death with Dignity Act. 60% of women and 70% of men supported the act. Catholics and Protestants alike voted against the repeal at 56% and 60% respectively. No religion voters voted against the appeal overwhelmingly at 89%. So, the Catholic perspective at this time. The Catholics continued to be against suicide and found that the issue of physician and guardian responsibility was still unresolved, as it said in 1982 by the U.S. Conference of Catholic Bishops. However, in 2001, the Church seemingly made up their minds, stating that they were in presumption of favor of providing food and water to all patients, even patients artificially kept alive, as long as the burdens do not outweigh the benefits. Sorry. So, Fackel v. Quill, 521 U.S. 793. Dr. Tim E. Quill, along with other physicians and 3 patients who have passed, argued that New York State's ban on physician-assisted suicide was unconstitutional, and made it so that New York's ban made it so that while patients can refuse life-saving treatments, doctors cannot help them attempt/commit suicide regardless of terminal illness or great pain. A district court ruled in favor of New York, then a second court reversed it. Then it was elevated to the U.S. Supreme Court. And in a unanimous decision, it was found that New York was within their constitutional rights to ban physician-assisted suicide in the interest of preserving the state's medical ethics, with the intention of protecting disabled and terminally ill patients from their own internal prejudices against themselves. That will come back. This court, even though Scalia was on it, found that the refusal of life-saving treatment was different and that the decision was different from the decision to commit suicide. Washington v. Glucksberg was essentially the same case. It was heard at the same time. It was decided on the same day. It was just in the state of Washington instead. But same thing, doctor, 3 patients. Their ban on physician-assisted suicide, is it unconstitutional? No. It goes against medical ethics to, condone physician-assisted suicide. Then the world was kind of at rest, and then the Terri Schiavo case came back. In 1990, at the age of 26, Schiavo had a heart attack that deprived her brain of oxygen and left her comatose. After 2.5 months of no improvement, she was diagnosed with persistent vegetative state. For 2 years, her treatment was attempted, but there was no improvement. And in 1998, her husband, Michael, petitioned the Sixth Circuit Court of Florida to remove her feeding tube. Michael's attempts were opposed by her parents, but ultimately the court sided in his favor, saying that Terri would not have wished for life-prolonging treatment, removing the feeding tube on April 24, 2001. Days later, the tube was reinserted. The legal battle dealt with those who had legal guardianship of Terri. It was found her husband had the right to make this decision on her behalf. Terri's feeding tube was taken out, and she passed away on March 31st, 2005. There were heavy protests among disabled and religious communities. Disabled communities that ending Terri's life was devaluing their own. Religious groups argued that it was against God's will to let Terri pass peacefully, as Terri was Catholic. Terri's own parents referenced a 2004 address by Pope John Paul II. So, Pope John Paul II gave an address in 2004 called Life-Sustaining Treatments in the Vegetative State, addressed to the participants in an international congress where the church took the official position that to provide one food or water, even in a vegetative state, was morally obligatory, and that medical doctors and healthcare professionals have moral duties towards these persons. Then there was Gonzalez v. Oregon. Again, the right to die was challenged from a different angle. Attorney General John Ashcroft claimed that the Controlled Substances Act made it illegal for physicians to prescribe the drugs that led to physician-assisted suicide. In a 6-3 opinion, the court held that the CSA was not intended to prevent physicians from engaging. It was intended to prevent physicians from engaging in illegal drug dealing, and that the CSA did not authorize the Attorney General to authorize or deauthorize medical procedures deemed legal in one state. So, states that have legal assisted suicide. You can see them all here. The 2 of note, I want to say, are Montana is sort of weird because it was decided in Baxter v. Montana 224 P3D 1211 2009 that there's nothing in the Montana Constitution that expressly bans physician-assisted suicide, and that therefore it's legal. There was never a law passed that protected this right, though, and Montana has at least 5 times introduced legislation that would make it illegal, but it never gets past the House. In Vermont, the lawmaker that led the bill to be passed, Willem Jewett, used this act to euthanize himself in 2022. There's also disability groups against assisted suicide. A lawsuit was brought as recently as this year that argues that California's physician-assisted suicide laws prejudice against people with disabilities. Many disabled people feel that they have been pushed to consider physician-assisted suicide rather than having their conditions be adequately treated. They claim they are made to feel burdensome and that their desire to die does not come from a desire to go out with dignity, but an inability to live with dignity due to a lack of proper medical care. There's some activism groups for assisted suicide. The 2 biggest are Compassion and Choices and Death with Dignity. Compassion and Choices mostly works on a personal level. Death with Dignity mostly works on a lawmaking level. So, the process of how you would actually do this. You have to be of sound mind, you have to be above the age of 18, you have to be able to take the medications themselves. There's up to 100 pills in these bottles, and you have to open all of them and dump them into a glass of water, dissolve them, and then drink them. Some say that the decision to require the person to take the medications themselves unfairly prevents people who are unable to use their arms or have Parkinson's from being able to use this law. A written request must be written in front of 2 witnesses, one of which cannot be family. After 15 days, there has to be another written request submitted. 2 physicians must confirm the diagnosis of terminal illness, and then the pills are prescribed, and they must be taken voluntarily by the person. There are sources, and that is done.